President Muhammadu Buhari approves the appointment of Justice Dongban Mensem as acting president of the Court of Appeal as Justice Zainab Bulkachuwa retires after clocking the mandatory retirement age of 70. On this episode of the program, Justice Bulkachuwa shares with us her thoughts on some prevailing legal issues. We also have the views of some senior lawyers on her tenure and the kind of reforms needed at the Court of Appeal. Plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. She was born on the 6th of March 1950, an indigene of Gombe State in northeast Nigeria. Justice Zainab Bulkachuwa had her early education in Kaduna before proceeding for her secondary education in Ilorin, Kwara State. She graduated from the Faculty of Law of the Ahmadu Bello University, Zaria, with honors in 1975. She was called to the Nigerian bar in 1976. She started a legal career at the Ministry of Justice, Kaduna, after which she was elevated to the bench as a magistrate in 1980. She was appointed a judge of the High Court in 1987 and a justice of the Court of Appeal in 1998. She was sworn in as president of the Court of Appeal in April 2014, and by that appointment, she became the first woman in the legal history of Nigeria to serve as the president of the court. I got a rare opportunity to ask her a few questions about some contemporary legal issues. I began by asking her to proffer some solutions for decongesting the dockets of the appellate courts.
So many cases go to the Court of Appeal and to the Supreme Court as of right. I think those matters should be carved so that not all cases go to the Court of Appeal. Like we have chieftaincy matters. They've been tried from the, from the High Court, some even from the customary courts. There are laws, what can I call them? There are decided cases on so many of them, on all the issues. You cannot change it. So unless a matter is of national importance, I think it should be stopped maybe at the High Court. And then if it has to go to the Court of Appeal, let this Court of Appeal decide whether it wants to hear it or not.
So the Court of Appeal should have the power to decide?
Should have the power to decide which matters should go to it on appeal. So there has to be leave of the court. I think that's what happens in other countries like the United Kingdom, the USA. We should limit the kind of cases we go. And then in election petition matters, I think not all matters should go to the Supreme Court. Not all matters should go to the Court of Appeal. Some should end at the tribunal level. And then the politicians have a habit of, let's say, 10 parties participate on one seat. Each and every one of them would go to court. It's the same facts, it's the same law. So why waste the time of the courts? And then if we don't hear the cases, their complaint is that they are not given fair hearing.
Justice Bulkachuwa also shared with us some of the measures she took to decongest the courts. She makes a strong case for a conducive working environment for her colleagues.
We are not that many. And then, like in the Court of Appeal, the number of justices should be increased. As at now, I think the limit is 90. Let's say in Lagos, if we have about 15 justices of the Court of Appeal, and we have 4 panels sitting, the pending cases would be reduced within a very long time. I think for 2 or 3 years, what I did was to empanel task forces, like in Benin, Lagos, Abuja, Port Harcourt, Enugu. That's where we have our heavy cases. So what I did was to empanel those from the divisions that have lower cases to go within 2 weeks to hear those appeals. So the numbers were reduced drastically. I think in about 6 months we decided about 3,000 plus cases. So if we can adopt that, we can decongest the courts. And then good working conditions for the judges, good courtrooms, at least before budgetary allocations are made, they should hear our needs. They should know what we need. I was restricted because I couldn't build as many courts as I wanted. Enugu Division is one example. The court was built, I think, over 20 or 30 years ago. It was built by the Ministry of Works. They didn't have any idea what a courtroom should be. So they gave us a courtroom at the end of the day. The same thing with Benin. We had been having problems, but because of the funding, we cannot even start building. It's only now that we've been able to complete those that were started at least about 10 years ago, like Ilorin Division, Yola Division. I think I opened the court with a temporary courtroom in 2010. Even then, contract had been awarded for the building of the permanent court in Yola. Look at the time it took us.
And even though she advocates for better funding, I took her up on the issues of corruption on the bench and in the judiciary. Here's what she had to say.
Well, as a judicial officer, if you make an allegation, you have to prove it beyond reasonable doubt. Allegations of corruption are criminal in nature, so they have to be and must be proved beyond reasonable doubt. You just take it, for instance, and say, this one had been given so much and so much. Where is your evidence? Where is your evidence? And then you don't know the method, you don't know the whereabouts, you don't know whatever. You just put it on the social media that such and such a judge had been given money. Do you have any proof? There was a time they put it in the newspapers that I was given 6 billion naira. So if I were given 6 billion naira, you think I would still be here? Huh? They make all sorts of allegations without proof, without anything. So you cannot even say, I don't have any evidence to say that any of my colleagues had been bribed or had been compromised. I made it a rule. Once we start these election petitions, I don't see any politician. My husband is a politician, but politics is a no-go area in our house. Let him go and do his politics. Let me come and do my judging. So that's how it has been. My children know that you don't bring any politician to the house. You don't. So I don't know the way the others run their lives. And then I expect if any allegation is made, it should be proved.
I recall that she was asked to recuse herself from the presidential election petition appeal. How did that make her feel, and what informed the decision she took?
So I told you, politics is a no-go area in our house. We hardly discuss it, and then he has his office where he does his politics. I'm his wife at home, and then I'm the president of the Court of Appeal in the office. He doesn't know what goes on. I don't know what goes on. So I'm not interested to know. But the issue is that people just assume that you are going to be biased. I'd been a judicial officer for 40 years. I've learned from a very early age. I was 30 when I was first appointed as a judicial officer. From that time, I've learned to separate the two. I know I'm a judge. I know I have a responsibility to my nation, and then I have a responsibility to my God. I'm going to be accountable to him one day. So I try to restrict myself to live within my judicial conduct, my judicial oath of office, and then with my conscience. That's what I believed in. So that's the way I had always handled my cases. You know, when that case, the presidential case, came in, I'd even forgotten that my husband was a politician. I'd even forgotten that I could have just gone. I thought being the president of the court, being the number one in that court, I would have been the best person to handle that matter. I had no doubt that I would have done justice to that matter. But once they raised that issue, they raised a doubt in my mind. A doubt is that no matter what I do, no matter what I say, it would not, Nigerians would not look at it because they are always looking for a scapegoat. They will not look at it in the way I would have looked at it, that I'm a judicial officer, that I'm being impartial.
And that you can separate politics.
Yes, and that I can separate the two, but they will just look at it as, her husband is a politician, he influenced her. So I wouldn't have felt okay in my mind. That was why I recused myself. Otherwise, I would have continued.
Despite the issues of corruption trailing some judicial officers, Justice Bulkachuwa says she doesn't believe in the suggestions made by some senior lawyers for retired judges to be allowed to sit on election petition cases. She also does not think that lawyers should be appointed to the Supreme Court.
If they will start from the beginning, from the High Court, I don't mind they are coming into the, but if you choose to be an advocate for quite a while, you've made a name for yourself, why come back? Huh? The age limit is 15 at the Supreme Court. Senior advocates have served for at least maybe 20 years or more, so why come down? And then advocacy takes a lot of training, a lot of sacrifices. You are confined by the salary structure, which is not that much. You are confined by the conditions of service. A magistrate might not even have a house, he might not even have a car. We have instances where magistrates travel on Akadas. And then somebody who had made it is a big man. He's an SAN. He has a fleet of cars, he has a fleet of aeroplanes, whatever. You bring him back to the Supreme Court. To do what? Huh? And then the training you do as a magistrate and as a High Court judge, you know, it takes dedication, it takes perseverance, it takes interest. So you've been working all that while, and then you manage to get to the Court of Appeal. At the Court of Appeal, you are posted from this place to that place, from this place, and then you are, you persevere, you get used to what is being. Sometimes you might go to a court where you don't even have an AC, you have a house where you don't even have a proper study, or you just use one room. I saw a house in Kaduna where the house was going down, so there were only 2 bedrooms for the justice to stay in. That was what she was using. It was a house of 5 bedrooms, so she was just managing with those 2 rooms. And then you manage for all those years, and then somebody would just come and take over your place. Is it fair?
The immediate past president of the Court of Appeal says she's satisfied that she's done her best on the bench. She also reiterates her confidence in her colleagues.
I think we had been doing the best we can in all those matters, and then it's only in 1 or 2 controversial cases that the Supreme Court had upset our decisions. But always, I think they give the stamp to what we do. We are very thorough in the Court of Appeal, that's sure. And then I'm very proud of the justices of the Court of Appeal. Look at the election tribunals we've done. We handled over 800 matters, and we did them within the time frame, and then in the best way we could. The most important thing is to do each case the way you see it. The important thing is to make sure that at the end of the day, after you've determined a case, you are clear in your mind that you have done the right thing. So I had so many cases of that challenge, but once I finish them, once I've written a judgment I'm satisfied with. You know, that's why when I deliver a judgment or when I write a judgment, I don't look at it. I leave it for a week or so. If anything is wrong, you know, it will come back to me.
It will keep recurring.
It will keep recurring in my mind. So I'll sit down and correct it. And then once I've delivered it, that's the end.
Now, some senior lawyers have been speaking to Law Weekly about Justice Bulkachuwa's tenure and some reforms that could aid speedy dispensation of justice, especially at the appellate court. We have their views. up next.
She made an history. At least for the first time we had a female president of the Court of Appeal, and since 1976, it's unfortunate that it was only her that became the first female to be president of the Court of Appeal. Then and within the period, it's been a glorious period for the Court of Appeal. There are a lot of reforms. We had this fast track criminal appeals. It's a period that administration of criminal justice law, administration of criminal justice in Nigeria was as a boost, because we have accelerated hearing of our appeals. It was never like that before. So before we used to have appeal that will last for 4 years, but within those former governors, our appeal lasted for 6 months. And they were all with 5 brief, everybody, the court took arguments and judgment were given within 6 months in all those. So these are things that were not, it was not like that before. So it was a great improvement during our tenure, and we really enjoy the reform that she carried out. But the aspect that I think we need to do more is that the justice of the Court of Appeal were being overworked, and then the aspect of electoral thing. The court, the judiciary is getting too much involved in electoral matters, so that we have little or no time for other cases. It's a problem that courts have been involved in the issue of election, or who's to be candidate of a political party. Our forefathers, they have their wisdom in saying that anything political, courts should abstain from it. I think we need to go back to those areas.
She creditably discharged the responsibilities of that office to the best of her ability. Within this period, it's of note that she had created more divisions in the Court of Appeal, and she has also improved the staffing generally of the Court of Appeal. Cases are duly more easily filed these days, more easily processed. But one area that probably we would need improvement is in the area of congestion of matters. I know that we operate a democratic system under which you have so many appeals arising from pre-election, post-election matters and disputes. So, as we embrace democracy, as we embrace rule of law, electoral system, and electoral reforms, we should also ensure that we take into account the capacity of the judiciary to deal with such matters. What that would mean is that we need to double the existing capacity at the Court of Appeal. We need to have not just more divisions, because some divisions hardly have matters going there. What we are more interested is working out the acceptable ratio of number of judges, number of justices, and to the number of matters pending. Number of panels as opposed to number of matters on the cost list. We need to have more panels in some zones. For instance, in Lagos, we have just 2 zones. No, it's not sufficient. We need up to 6 zones, 6 panels of that court sitting at the same time. That is the only way we can decongest.
I must tell you that she's had a very successful tenure of office. She is very hardworking. She's very down to earth. What she bothers about is her concern, is how justice will be best served. And then to that extent, she has taken it upon herself to ensure that she's brought justice closer to the people. What am I talking about? Now, during her tenure, she's succeeded in creating additional divisions of the Court of Appeal. So she's really done excellently well. The whole essence of justice is to bring it closer to the people, so that people would spend or will care less expenditure in the process of seeking for justice. She has done excellently well. It is work in progress. My Lord has come, she's done her own. I've mentioned that she's really brought justice closer. People created a lot of divisions. When the next person comes, what we will look at is how do we introduce automation and technology into some of these things so that everything does not have to be done manually. I think that area we need to look at it.